yesterday we had very interesting panels and talks, and we saw that academics and also the people in the industry had the same approach, which wasn't necessary because people come here to agree or disagree, but they were speaking about purpose. We saw previously academics, scholars speaking about purpose, maybe was already here, and new regulation, maybe it's not necessary. Afterwards, the people from the industry working in Inditex, Zara, in Vodafone, in McDonald's, they didn't say anything about if purpose was here or not. They were speaking about what they had as a purpose, no? And afterwards, somebody asked, but do you think that new regulations are necessary or not? Well, we're here with our purposes, no? Today, we have the pleasure, the honor to have with us Professor Brian Cheffins, a professor of corporate law of the University of Cambridge, and you have his profile in the web of the conference, so I'm not going to invest time speaking about his prestigious CV, and I'm not going to steal his and even your time with more words by myself. I'm just agreeing, we come here to agree or disagree with the title of his presentation, of his talk, past, present, and future of corporate purpose, because sometimes studying the past helps to understand the present and to foresee the future. Then let's see with Professor Brian Cheffins, what about this past, present, and future of corporate purpose? Thank you very much, Brian. You have the floor.
Thank you very much. It's a pleasure to speak at this excellent international conference in corporate governance focusing on corporate purpose. I'd like to thank the Dean. I'm not going to attempt to pronounce his surname. Cheffins is a kind of tricky surname by English standards, but I'm sorry, I'm not going to do it, because all you'll do, I don't want that kind of laughter as I mispronounce his surname. But I would really like to thank him, the Dean, for inviting me to this conference. I'd also like to thank Beatriz Sanchez Garcia for all her help with logistics. Everything's worked incredibly smoothly, and it's been great to be here. The talk I'm going to be giving today is based on a working paper of mine. The SSRN link is on the title page. The paper itself focuses on developments in the United States, as will my talk today. Nevertheless, I'm going to conclude with a few remarks about the cross-border implications of the points that I'm going to make in my talk today. Now, in the United States, debates regarding corporate purpose are long-standing, with conflicting visions of corporate purpose extending back for decades. The controversy has intensified, however, recently. Concerns are growing that those running America's largest firms do not forsake prioritizing shareholder returns, then social and economic stability could be undermined, and the fate of the planet could be jeopardized due to climate change. A byproduct of this debate is that an already extensive literature on corporate purpose is exploding, and also with the related topic of corporate stakeholders. What really is there left to say about corporate purpose? I seek to make an original contribution to the literature by addressing a topic that has only been rarely addressed in a systematic way, which is the future of corporate purpose. Now, such an exercise is timely because amidst this ongoing intense debate regarding corporate purpose, various observers, largely as asides, have argued that a changing of the guard is occurring with corporate purpose in the United States. I say asides because, consistent with a general pattern with legal scholarship, there's been a tendency to de-emphasize forecasting in favor of explaining the current state of affairs, offering normative assessments of present-day arrangements, and generating policy recommendations in turn. My paper departs explicitly from the pattern. drawing heavily on past developments and present-day circumstances. As the Dean suggested, I think you can learn from the past and to learn about the present, and also to think where the future might be with respect to the trajectory of corporate purpose in the United States. In my paper, I explicitly invoke the notion of a corporate purpose cycle to sharpen the analysis of whether the currently dominant shareholder primacy arrangements will be displaced soon, because shareholder primacy is the departure point in the US. I maintain that despite various implicit claims to the contrary, a stakeholder-friendly pendulum swing is unlikely in the United States. I argue instead that a mid-1980s takeover wave served as a critical juncture in the United States that launched an era of shareholder primacy that is unlikely to end soon. Many trace the give and take regarding corporate purpose in the United States back to a much heralded 1930s debate between law professors Adolph Burley and E. Merrick Dodd, while others push the chronology back even further. To put my analysis of the trajectory of corporate purpose into proper context, I offer in my paper a succinct historical summary of corporate purpose trends in corporate America. In my paper, I describe initially how the configuration of corporate law in the 19th century tilted corporate purpose in a public regarding direction, sort of a stakeholder, but more public regarding direction. I'm going to gloss over the details for present purposes. I then describe how evolving early 20th century share ownership patterns, more publicly traded companies, combined with changes to corporate law to put corporate purpose in the spotlight in a way that had not occurred previously. The early case law jurisprudence was shareholder friendly, exemplified by the well-known controversial case of Dodge and Ford Motor Company. Next in my paper, I canvass the Burley and Dodd debate. I emphasize particularly the circularity with the positions these two academics staked out. Burley was shareholder friendly, Dodd was stakeholder friendly, but they flipped back and forth a number of times, which sets the stage quite neatly for the argument that there's been a sort of a circular approach with corporate purpose in the United States. Now, the way things worked, I've already indicated the way things started was that in the 19th century, there was a public regarding reproach in relation to corporate law and thinking about what companies are supposed to do. Then, as I said, in the early 20th century, there was a shareholder-oriented approach. In the mid-20th century, there was an era of what is known as managerial capitalism, which had strong stakeholder flavors, so swinging back again. And then finally, the final swing back was in the mid-1980s with a takeover wave that led to the current shareholder-friendly era. Now, I very much simplified the history for present purposes. It's a little more complicated, but what I wanted to do is to indicate that you can think about corporate purpose potentially in this kind of cyclical back and forth way in the United States. Now, what I want to think about is, and the implication would be, the current debates is that with the stakeholder orientation, we're going to get one more swing back, that it's going to become stakeholder oriented in the United States. Is that going to happen? Starting point for thinking about whether you're going to get a swing back is corporate law. Now, some suggest that U.S. corporate law obliges boards to run their companies in the interests of stockholders. In fact, no state corporation code in the United States imposes an explicit duty on directors to prioritize shareholders or any other corporate constituency. Moreover, U.S. corporate law gives boards substantial discretion to use their managerial authority in a stakeholder-friendly way, most obviously due to constituency statutes enacted in the late 1980s and to the business judgment rule, which was developed by American courts. Now, the fact that there is no explicit directive in U.S. corporate state corporation codes to tell directors that they have to run companies in the interests of shareholders suggests that ultimately the shareholder centrality that features in the United States is ultimately an extra legal phenomenon. And now, why is that significant? It's significant because it suggests that corporate purpose could change in the United States without major legal change. That you're going to get a change of norm structure, and there you're going to get a change of corporate purpose in the United States. And this arguably happened in the mid-1980s with the takeover wave, and what I'm going to explore is, could we be getting sort of a norms-oriented shift in the US towards a stakeholder-friendly approach now? Now, why might there be a shift in favor of a stakeholder-oriented corporate purpose in the United States right now? And here, I think that the COVID-19 pandemic played an important role. As the 2020s got underway, it provided an exogenous shock that accelerated pro-stakeholder trends that might have otherwise left shareholder centrality largely undisturbed. These include concerns about climate change and racism. Now, so there might be concerns that there might need to be a reorientation, but why is it that corporations are the focus of this? Why not simply go to politicians and tell them to change the laws? Well, there's a perception in the US that that government officials struggle to execute needed reforms. So correspondingly, you would turn to corporate executives who might well be able to make beneficial change, operating more effectively than government officials. How would public company executives react? They might kind of like this. One advantage is it's pragmatic, that if they act in a stakeholder-friendly way, they might be able to fend off unwelcome government regulation. Also, they probably kind of like being free from rigorous shareholder monitoring and shareholder-oriented constraints. They like a little bit of play that being able to run companies in stakeholder interests offers. Now, to this point, I've set up what is potentially a plausible case that corporate purpose is cyclical, moving back and forth. I argue in the remainder of the paper that the final pendulum swing, if you want to call it that way, is in fact unlikely to occur. Now, to provide context for this prediction, what I'm going to do now is canvass potential corporate purpose trajectories, because cyclical is by all means not the only way. Now, legal academics, as I indicated, tend to refrain from making explicit predictions about where law is going. However, there is a general implicit assumption that law does evolve. Societies change and law evolves in response. And you can use that term evolve despite the sort of potentially problematic connotations of being associated with Charles Darwin. Now, how does law evolve? Two potential possibilities: slow and steady change, and the other is long periods of stasis, so just status quo, then brief periods of rapid change. In the 1990s, political scientists imported the concept of punctuated equilibrium to address possibility two, that of nothing changing and then rapid change. Legal academics have now done the same, and the term punctuated equilibrium is used with some regularity, for instance, in relation to US securities law to describe how it evolved over time. When punctuated equilibrium logic, when it's been used to account for policy developments, there's been a tendency simply to go, oh, change just happens. What doesn't tend to happen is that the causation mechanism for change is left unidentified. It's just change happens. What is referred to as critical juncture theory can help to fill this gap. This theory has gained a firm foothold in the social sciences, but not much has been written about it with respect to legal scholarship. Under this theory, critical junctures have three key features. First, there's a fixed period of time, a window of opportunity, structural fluidity, heightened contingency, things are in play. Second relates to duration. This window for change must be only open briefly, that it's not always that change can happen. that it's just brief periods. And finally, what has to happen is that when the window is there, change with lasting occurrences has to happen. There needs to be sort of a path dependence. That is your critical juncture, that the way to break down your critical juncture that relates to how law evolves or other social phenomena. So that's an evolutionary change in relation to law. Now, what about a cyclical pattern? Now, both versions of events with respect to evolution, again, gradual or quick change, assume that the past is going to, that the present and the future is going to differ from the past. It's evolving, so it has to be changing. However, there's a cyclical conception of social change that is one of the oldest in the history of thought. Cyclical theory has been characterized as pessimistic because it suggests kind of a determinism. You really can only go back and forth between two things, and you're going to go back, so, and that's kind of depressing. But those advocates of cyclical analysis, at least in the humanities, they say, no, that's not really what we're saying. That what we're saying is that there can be these kind of rhythms and more attention should be paid to them to get a better handle on where things might be going. And I've indicated the history of corporate purpose can be characterized in cyclical terms. Are we going for one more swing? That's what I'm going to talk about now. Now, why might the, I've talked about why it is that there could be a move in a stakeholder-oriented direction. Now, how would you characterize this? So I've already talked about it in terms of it being a swing. Another way of thinking about it could be that it's a critical juncture, that COVID has brought on the period of structural fluidity and heightened contingency, and we could be in for a big change that's going to last. So a couple of ways of potentially characterizing this. But again, is it going to happen? I argue it isn't going to I don't think so. Why not? So having sort of set the table, we're going to get change happening, why is that in fact probably not going to happen? We need to return to corporate law. Now, you might be going, corporate law? He already dealt with corporate law. He said that corporate law is not a constraint on a corporate purpose change. Well, things are a little more complicated than that. And that's because under U.S. corporate law, even though you do not have an explicit direction to directors that they have to run companies in shareholder interests, shareholders do have key powers under corporate law. My slides have disappeared. Oh, well. I'll just have to go with it.
No,
they're back. Good. Not quite sure why. I guess I was a little slow. Now, so only shareholders in the U.S., they get to elect directors. They vote on corporate transactions and amendments to the corporate constitution, and they bring derivative suits. Lots of key things that stakeholders can't do. Now, this is not dispositive. It does not dictate where corporate purpose necessarily will go, because in the mid-20th century, the basic law was exactly the same as it is now, and that was a stakeholder-friendly era. However, what happened in the 1980s and the 1990s was that hostile takeovers made people realize just how important these shareholder rights were when they were pulled together. And what that meant in turn was that people went, okay, shareholders really should be the primary emphasis and focus for directors. So corporate law is an obstacle, not determinative, but it is an obstacle to a change. There are a couple of other obstacles to a stakeholder-friendly switch. One's executive pay. So executive pay changed in the 1990s in a very shareholder-friendly, incentive-driven way. That hasn't changed. So if chief executives want to get rich, the way to do it is to deliver results that shareholders want. That hasn't changed, so the priorities are going to remain shareholder-oriented. There is also, more broadly, what has been described by law professors Dorothy Lund and Elizabeth Pullman as a corporate governance machine. And what they say is that you have a vast array of institutional players, proxy advisors, stock exchanges, rating agencies, institutional investors, and associations ensure shareholder primacy in public markets. Now, what could lead to change given this terrain? One possibility is that shareholders could be the catalyst for in a pro-stakeholder direction. Okay, so the way that this would work is that currently now major institutional investors have a couple of incentives to conduct themselves in an ESG, don't think I need to do the acronym, friendly way. One is their clients. A lot of their clients want it. They want to feel that they're investing in a way that is consistent with the interests of the climate and stakeholders more generally. The other is ESG funds. You can charge higher fees, so that's quite convenient as well. Now, possibility could exist that this ESG stakeholder-friendly approach, if shareholders start using their votes, what could happen is you could get stakeholder-friendly board turnover and you could get executive pay change or reorienting things in a stakeholder-friendly way. Well, major shareholder-driven corporate purpose change, in fact, seems kind of unlikely. Powerful institutional investors, they're beginning to hedge their bets. They're talking now about their fiduciary duty to maximize risk-adjusted returns and saying careful in terms of the extent to which they should be, the corporation should be reorienting away from shareholders. Also significant is that ESG may have reached its peak already. Why would this be? Well, ESG really moved to the forefront when share prices were going up. So people could feel comfortable about getting rich at the same time they felt good about what they were investing in. Shareholder returns over the past few months, not so good. So people might be a little less comfortable with that. And as I said, ESG funds, they charge more. In a negative market, people may begin to be more concerned about that. There are also concerns about inconsistencies about what ESG means, so maybe the ESG momentum will ease off. So if shareholders won't do it, what about corporate law reform? I think it's unlikely you're going to get the laws changing to bring in corporate purpose change. State law, so in the US, corporate law is state-based. There is no federal corporate statute. And state law, in the 50 different states, it changes incrementally. So some kind of quick flip in corporate purpose, unlikely. Even more powerful is, in the US, it's not a perfect market, but there is a market for corporations. And if you had a state that went right out in front with a very strong mandatory pro-stakeholder arrangement, what would likely happen is the corporations in that state would migrate out. And the awareness of that possibility will stop them. So that suggests you're going to need federal intervention. And there were, in the late 2010s, a series of proposals to bring in a federal statute which would have been very stakeholder friendly. But are these ever going to be enacted? Federally driven corporate law reform, primarily through securities regulation changes, appears to be restricted, looking back in the past, to rare critical junctures involving a combination of a prolonged stock market slump and substantial public antipathy towards business. 3 examples: federal securities law in the 1930s, Sarbanes-Oxley 2002, Dodd-Frank 2010. Those are the critical junctures. Those are the big corporate law changes by the feds. But these are rare. So there were stock market crashes in the early 1920s and the 1970s. No change. They're rare. And the other is, with these past changes, none of them have been stakeholder friendly. So what's going to change now? Unclear. So I'm going to wrap up now my US portion. And then, as I said, I'm going to make some comments about broadening it out from the U.S. With respect to the U.S., so there's been what I've sought to do is I've sought to make an original contribution by looking explicitly to where corporate purpose is going. A case can be made that there's a cyclical pattern going on with corporate purpose, and that suggests it could be going stakeholder friendly. But I've argued that, in fact, that seems unlikely. Assuming that that's correct, then I think there's a way of recharacterizing what happened in the mid-1980s. Mid-1980s arguably was a critical juncture. Hostile takeovers completely scrambled everything, and you had lasting change. So from a corporate purpose perspective, perhaps the correct way to think about it is to use critical juncture analysis, and the mid-1980s were crucial in offering decisive change. This would be kind of a depressing prediction for a lot of people in the US. What this suggests is that you're going to need to look beyond corporations for change. What you're going to have is you're going to have to go to public policymakers to get the changes you want. Okay, so talk about the US briefly. What I'm going to talk about now is I'm going to talk about corporate purpose, and then I'm going to talk about corporate law trajectories. Now, what I talked about was the US, okay? What I said for other jurisdictions, you might find it to be of interest, but not relevant. So with continental Europe, the starting point is different. Prioritization of shareholders, outside investors in continental Europe, has shallower roots than it ever has in the United States. And so what that would suggest is that to the extent that there are ESG, stakeholder-friendly momentums, that could push things in a stakeholder-oriented way considerably easier in continental Europe than it would in the United States. And that's indicated, I'm sure you're going to have a litany of examples yesterday and today, but France's PACT law 2019, corporate sustainability initiatives, which you're talking about extensively, that whatever pro-shareholder momentum there might have been around 2000, that's probably stopped. Now, this ties into what is probably the most famous prediction regarding corporate purpose, and this is Hansman and Crackman. What they did is they predicted in 2001 the end of history for corporate law, and they maintained the triumph of the shareholder-oriented model of the corporation over its principal competitors is now assured. So shareholder primacy had won. That looks right for the US, as I've already described. But they didn't limit their prediction to the United States. They said that instead, with the end of history, that it had global reach, saying that across developed market jurisdictions, continued convergence towards a single standard model is likely. That single standard model, that was shareholder primacy. Now, is that, in fact, that prediction, the end of history for corporate law? That looks considerably more doubtful. Corporate law trajectories. Now, I've suggested that critical junctures can offer insights with respect to thinking about how corporate law evolves in the United States. And you might, if you've been following the argument, go, well, geez, what about elsewhere? Does this have any resonance in other jurisdictions? Based on the two countries I know best, Canada and Britain, no, I don't think so. So again, that can be sort of an interesting observation you can just sort of park, because in Canada and Britain, the way things have worked is that when you get major corporate law reform, it evolves from a basic sense that corporate laws got badly out of date and is no longer fit for purpose, and then technocrats change it and tweak it to make it more modern. Just happens. Isn't related to things like stock market crashes or that kind of thing. Just sort of goes along, and then they just change it. Why is the U.S. different? It's U.S. So the way I think it's federalism in the U.S. So Britain is it's not a unitary jurisdiction, but anyway, just assume English company law, okay? And they just do it, and they don't worry about regions. There is Scottish corporate law. Ian's out there somewhere, I assume, but it's just a few tweaks. Anyway, so they kind of control it. Canada, the way it works is there is provincial statutes like the U.S., but Canada is always kind of different a little different than the U.S. So there's a federal statute that kind of dictates everything. It's the tone setter. And the bureaucrats run that, and they just change it. U.S. is different because what you have is you have the states and you have the feds. And the feds only come in at critical junctures when big stuff happens. Otherwise, they just let it tick over. And that's when you get the corporate law change in the U.S. So that's arguing that critical junctures analysis for corporate law. Now, it doesn't mean that, there was this critical junctures term. What the heck, how relevant is that? I think it can be relevant in other areas of law. Corporate law, corporate purpose outside the United States, I'm not so sure about. So that's that.
Thank you very much, Professor Cheffins, with such an easy surname. Thank you, Brian.
That's only one. Only
Yes,
one.
I need a foldable business card, yes, even in Spain. Thank you for your ideas, and we have now time for some questions, some debate. Then now you have the floor. There's a microphone which can be just. Okay, thank you very much.
Hello, thank you so much, Professor Cheffin, for your excellent presentation. My name is Hugo Cardona. I am professor of the São Paulo University. And I wanted to ask you a brief question, because some years ago, I read an article from a business-oriented approach of corporate purpose of Professor Michael Porter and Professor Mike Kramer from Harvard Business Review regarding the shared value idea of companies. That, of course, this is something that is taking us from a shareholder capitalism to a stakeholder capitalism. But, of course, from a business-oriented approach, don't you think that would be this idea of corporate purpose better oriented to integrate into companies from a self-regulation perspective and not from a legal perspective? Because this is a change of mindset in companies, of how they are managed and how they are organized. So this is a philosophical change, basically, in companies, how they are operated in a daily basis. So don't you think that would be better suited to leave these issues to self-regulation rather than from a legal point of view, trying to implement these ideas in how companies are managed? Thank you so much.
So what I'd say in relation to that is that, in fact, I do think that that is how corporate purpose changes in the US, because the law doesn't dictate it. And so that it is driven by market factors, and that would suggest that, again, the way that change is probably going to occur in the US is going to be from inside the corporation. Given the shareholder orientation, shareholders have to be working with the grain with that, I think, in order for that to happen, however. If corporate executives make that kind of move and they haven't had shareholder buy-in, then what's going to happen is that they're going to run up against shareholder activism with the various components that I've talked about. The difficulty with self-regulation, though, from corporate purpose is impatience. So people think right now that that climate change and race issues demand instant change, or it's going to be it's going to be a social cataclysmically from a societal perspective. And so the difficulty might be that while perhaps it's preferable to have change from within the corporation, the difficulty is going to be that there are a lot of people who are worried about these issues who think that's simply too slow. And if they'd listen to a presentation like mine, they'd be going, well, ultimately, it isn't going to happen from within the corporation. So therefore, it's going to need to happen externally. So as a normative matter, it may well be better if change is going to happen within the corporation. But will it happen? My prediction is no, and therefore, if the changes that are thought to be essential are going to happen, it may need to happen externally.
Thank you. More questions? Okay, then we are on time for the next panel. Thank you very much, Brian. Thank you all. I hope that you have profited this nice opportunity to having a professor of Cambridge University at our university, and the conference continues in a minute. Thank you very much.
Thank you.